There's an update with the Alexee Trevizo case. She was in court yesterday with her lawyer. Well, not physically in court. This was all done via Zoom call, I believe. But there's an update with the case regarding her side and whether or not she's going to be allowed to attend university class. Because, again, she was a senior in high school when this happened back in January 27th of beginning this year, 2023. And so she graduated, she got into college, and now she's going to be able to attend university classes. But they're also going to talk about the no contact order between her and, I don't know if they're still together, her and her boyfriend or ex-boyfriend, Devin, and as well as other stuff. Remember how we watched some videos last week with her mom? You know, there's some videos where she was threatening law enforcement. She was threatening to sue the hospital. And it was kind of previewing what she was probably planning on doing in the future. What she did end up doing was sue the hospital, or, you know, Alexee Trevizo and her family. They are suing the hospital. So they're going to go up there. Gary Mitchell is her lawyer. He's going to go up there and talk about, oh, you know, the hospital, they broke HIPAA and stuff like that. Shouldn't have released the footages to the police department. Shouldn't have, you know, somehow there was the rumor that spread to the school or within town after the incident happened. So I was thinking, you know, maybe people found out because maybe people at the school saw that she was pregnant, knew she was pregnant, you know, thought she was pregnant. And then one day when she came back from school, it was like, oh, well, where's the pregnancy? Where's the baby? What happened? Like, what did you do with it? So maybe that's why the rumors were you know, circulating around. But I don't know. Maybe there was people who worked at the hospital that talked about it, and then word got around town, you know, because apparently this is a small town area and everyone knows each other's business. But hi, everyone. How are you doing today? Taxi, Melissa, Jesus, Enriquez, Rachel. Hi, Valerie. Hi, Dave. Hello, Aylin. Aylin says, hello. Her and her family have so much audacity. It's crazy. Yeah, so when the trial does happen, initially it was scheduled for, I think, somewhere in October, November, but it's been pushed to next year, 2024. Oh my God, 2024. It's going to be 2024 soon. Is that wild? Oh my God, summer's already over. It's going to be Christmas and Thanksgiving soon. October. Okay, I'm sorry. Okay. I just can't believe how fast time flies. I don't know. But yeah, so her trial is going to happen beginning of next year. And her side of the story is that, you know, the baby was born. She did give birth in the hospital bathroom, but her and her defense team are maintaining that it was a stillborn. However, the state side, they're saying that this was a murder, that she deliberately, you know, murdered her child. And the baby, when it was born, did have air in its lungs. And I believe there's also air that was found in the stomach as well. So, and we both know, or sorry, not we both, but we all know that based on what the hospital staff said, they said that they never gave the baby CPR or anything or attempted any life-saving strategies, because you can clearly tell that the baby had already been deceased for a little bit. Because I think by the time that the housekeeper discovered the baby's body, it might have been almost like an hour since Alexee Trevizo first went to the bathroom, I believe. But yeah, yesterday, you know, I had this in my calendar, and there's a reason why I have a calendar here. I must have forgotten to look at it. I didn't stream on YouTube yesterday. I decided to take a break, play some Baldur's Gate, stream on Twitch instead. But I missed the motions hearing that happened yesterday at 1:30. And I don't know if it was live stream. It might have been live stream. I think so. I think Law and Crime or Court TV may have like live streamed it. So I'm sorry, y'all. I missed it. It was in my calendar and I completely forgot. So we're going to watch it today. It's about roughly an hour long. They're on a Zoom call. We have the judge there. We have the defense attorney there. And we actually do have Alexee Trevizo sitting in the background. At first, I didn't even notice her. There's we're in Gary Mitchell's office. And then it looked like there was like a cardboard cutting of someone who's just like in the background. But I think it's Alexee Trevizo. I think she's sitting back there. And we'll watch the footage together. But how are you guys all doing today? How's it going? Oh, I think I forgot to turn on one of my lights. Give me a second. I have one additional light right here that I didn't turn on yet. But while waiting for that, I don't know if you guys follow me on Instagram, but I just posted my pictures that I took with my film camera. I bought this film camera that was made back in 1982 or something. Super, super old Canon camera. And we got our film developed for the first time. And I don't know how to take pictures with film. Okay, I actually had an issue with loading the film into the camera. I was trying to load the film in. I fucked up. I was watching a YouTube video, didn't know how to do something. And the film ended up getting sucked all the way back into the canister. And I didn't realize, but in order to take it out, you have a special tool to do it, or you can do a trick with another film thing. But yeah, it's been a whole mess. But we finally got our pictures developed, and I really like them. If you guys want to go on my Instagram, like at the end of the stream or something, check it out. I don't know. Film is so cool, but it's just so expensive. And it was $14 to get those photos developed and scanned. Not even printed, just developed and scanned. But okay. All right. I got my light on. Everyone's all here. Jesus Rangel says, I still can't believe Trevizo's trying to put this on the hospital. Not to mention they didn't mention where they found her newborn in the lawsuit. I mean, I can understand why they excluded that, but you know, at some point the judge priority knows. But yeah, the jury will find out as well. Hi, Hansha. How are you doing today? You're from the mountains? Wait, you're in California. You're in Colorado. I love Colorado. I want to go back to Colorado. When I went there, it was really cold, but the air was so nice, so crisp, and like, oh god, just like, oh, that fresh air. I loved it. I want to definitely go back. Aylin says her defense team is off their rocker. She still threw it and left it in the dead for a public bathroom. Yeah, but obviously if they are able to prove, so when the trial happens, they're gonna have, you know, different experts. Her team is gonna say baby was a stillborn because of XYZ, maybe the medication, hospital, negligence, whatever it is. And that's probably why they filed a civil lawsuit, to be honest. And then the state is going to say that like, hey, no, we did our own autopsy and there was air in the lungs. And this is because the child took breath before subsequently it was put into the trash and probably suffocated to death, right? But yeah, we're going to have different experts go up there and it's going to be who the jury is going to believe, which side they're going to find more credible. But yeah, if they were able to find out that, you know, if Alexee and her team were right and the baby was a stillborn, obviously she's gonna get off a lot easier and she'll probably just get charged with, you know, improperly maybe disposing the baby in the trash bin, which is going to be less of an offense, obviously. But yeah, we'll see. You know, I think a lot of people are really livid about this case. A lot of people, you know, are really emotional as well because at the end of the day, the baby was found in a trash bin. And, you know, watching the body cam footages, watching the interviews with all the hospital staff and saying that, like, you know, they found her to be highly duplicitous. You know, when she came in, she was saying she wasn't pregnant. I know, adding all that up together, it really does sound like she was doing her best to hide the baby, no matter the cost, no matter the means, and the way that she walked out of the bathroom, acted like nothing happened. It is very jarring, and it is kind of one of those things where it goosebumps all over you because I don't know, that it freaked me out so much because just seeing her walk out of the bathroom, act like nothing happened. Anyways, so we're going to watch the motion hearing that happened yesterday, and I'm going to switch over to this one right here. I think sometime this week we're going to resume the depp v. heard sidebars. There should probably be one more stream that will cover that. I think it'll cover, I'm pretty sure it'll cover everything. I don't know, it depends on how many sidebars there are. I'll take a look at it. But I saw this pop up yesterday and I was like, oh shoot, I forgot about this hearing. So we'll cover it on today's stream, and then I'm probably gonna film some stuff maybe or work on some stuff. And then later on the week, we'll continue the depp v. heard sidebar stuff. So thank you for your patience. And I know I was gonna go through the weekend and finish it, but I don't know. I was just trying to enjoy my weekend. I'm gonna just be honest. I was just trying to enjoy my weekend. Okay. All right, y'all. I hope the audio should be good. Everyone has their microphones, Zoom calls. Hey, Nacho, how are you doing today? To answer your question, you are skipping Starfield. You have zero faith in Bethesda at the moment. The launches are historically bad. So maybe wait it out a little bit, you know, until, like, if there is any glitches. Yeah, that's good. That is good. That is good. All right, so we have police officer. I don't recognize any of these names. All right, I'm going to forward it just a little bit. I have the captions on too. So if y'all need the captions or anything. And if there's anything that, I don't know, I'll try to.
There's Miss Lou. She's also signing in.
Okay, so Jane Gray. I think Jane Gray is the judge. Gary Mitchell's over here. That's Alexee Trevizo's lawyer. Alexee Trevizo, you could barely make her out, but I think she's sitting back there. I just recognize her because of the glasses.
That's your client in the background, Mr. Mitchell?
Oh, thank you so much, Judge. You're just asking what we're all thinking.
It is.
Okay. All right. Okay. Thank you, sir. Just want to be sure we got our necessary parties here. Let me call our case number. This is, excuse me, CR 2023-159, State versus Alexee Trevizo.
I turned the audio up. Let me know if it's good. Let me know if I need to do anything else. My hair looks nice today. It doesn't always look nice. I'm just kidding. Hi, Copen. Thanks. Thank you. I appreciate it. Her lawyer needs a serious camera upgrade. I mean, I know, I can see why he doesn't want to, you know? Who wants to have like his, like, you know, he doesn't want to be clipped in HD on YouTube thumbnails and stuff, okay? If I was him, I would have my blurry ass webcam too, all right? Y'all getting nothing but pixels from me.
Diana Luce is a district attorney. She's appearing for the state. Mr. Gary Mitchell appears as counsel for the defendant, and she is also appearing in person, virtually in person. So, counsel, we've got several matters to go through this afternoon, several motions. I wonder, do you have a preference as to the order? I was proposing we deal with the venue change as the first order, but if you have something else.
Oh, yeah. So that makes sense. So her defense team wants to have a venue change, which makes sense. I don't know how small this town is, but it seems like it's pretty small. People know each other, very gossipy. I don't know, news circulates. So obviously defense team wants to have a, you know, change in venue because maybe people in town, a lot of people have already heard about this case and they don't want to have a jury pool that's already been tainted and have their minds made up. So I wouldn't be surprised if the judge granted this. But again, I don't really know this town, but it might be a really small town.
Else you'd rather take in any other order? I'm fine with that.
No, Your Honor, I can do with the venue. It'll be pretty quick.
Okay, all right, okay. So it's your motion, Mr. Mitchell. I'll let you tell me what I need to know, and I'll hear from Ms. Luce. And I do have your pleadings here, of course.
Sure, and I'm not going to repeat those. Your Honor, classically, we'd have a hearing over whether or not Eddy County is free from exception, and I'd file affidavits and do all that. But
Quick question, though. What do you guys think? Do you think the judge is going to grant it? Do you think they're going to have a change in venue?
the new basis for doing these change of venue motions virtually has turned into
Hi, Lisa.
something that was suggested several decades ago by judges like Allen and some of those judges. Whenever we would, they suggested that rather than do change of venue motions, that we send out and ask the courts for questionnaires, and we send out questionnaires that we ask people to fill out under oath, and then the council reviews those questionnaires to see if by perchance we can get a jury, which seems to be much cheaper and frankly a better way to do it. Ms. Luce kindly sent me the latest questionnaire that they used in a similar case out of Hobbs or out of Lovington. I got that. She and I can make some modifications to that. The trial date you sent earlier.
Oh, interesting. Okay, so previous judge, I think there was another judge before the case transferred over, but previous judge was like, hey, instead of just doing like a change in venue, why don't we just do questionnaires and see if we could get people that haven't already been tainted?
Today is acceptable to me. I think it's acceptable to Ms. Luce, and we can figure out with you and the court clerk when we should send those questionnaires out via Google, however we're going to do them. That's up to the clerk, but I'll get with Ms. Luce. We can work up that jury questionnaire, get it sent out once we get the new panels that would be sitting for that trial. And then when we get the information.
That's what I said, Rachel. At first, I didn't even notice her back there. I thought she was a cardboard cutout as well. I don't know how our lawyers are willing to take on defendants like this. I think he's a public defender. Isn't he? I feel like I've asked this before and I got my answer, but I don't remember. I think it's a public defender.
We can figure out when counsel can sit down and go through that with the court, move to strike certain jurors who, by the answers on the jury questionnaires, have given us sufficient information for which they could not sit fairly and impartially, and decide if we have enough jurors to select from, and then go from there. I would propose that to the court as a way to resolve this issue rather than have a lengthy hearing today.
Maybe not.
Over whether or not this case has nationwide publicity, countywide publicity, statewide publicity, or world publicity. It has all of them, frankly. So trying to move to another.
Maybe not public defender. I thought it was a public defender. Maybe not.
Jurisdiction may not in New Mexico may not be very suitable since the whole state has some of the same media sources, and particular social media has been so explicit in this particular instance. That's the solution I propose.
All right. And are you on board with that, Ms. Luce? I mean, it sounds rational. We all know there's no place to go that somebody hasn't heard about the case, which is not, that's not the standard for qualifying or disqualifying, but nevertheless, there's no place we can go that would be any different, my opinion, than Eddy County. And I think that's what I'm hearing from Mr. Mitchell. Are you on board at least with the concepts?
Where's Eddy County?
Yes, Your Honor. That's why I provided the supplemental questionnaire we used in the case that we tried in Lovington, so that he could see the questions we did. Obviously, he and I can confer. If we can't agree, then on it, we can have a hearing before the court. But I think if we can agree, then we can just submit it for the court's approval.
Oh, okay. I mean, Eddy County does include Artesia, so.
The court can submit it to the clerk's office, and then they'll digitally upload it as they did in Lovington, and then they'll send it out paper for jurors that need that. But I think that resolves that motion for today.
Okay. And folks, let me take, it's above my pay grade. I don't know how Martha does her work down in the clerk's office, but my suggestion is that we get with her early enough, and this trial's not going anytime soon, so we should have adequate time to let her know we're going to have to get an unusually large number of jurors pulled in to examine a panel. I mean, just the length of the trial alone is going to make it difficult to get an adequate veneer to pick from. So at least we've got some ramp up time, and then I'll let Martha know, kind of be warned, we're going to have a really, really large number of prospective jurors to sort out, I think, in this case, just to get enough people to sit on a panel. And I think you told me you expected 6 weeks to try this. Is that right?
How can she explain hiding and dumping her baby? I bet she's not going to testify. So they'll never have to really ask her that and have her explain that. If she does testify, though, then yeah, they're for sure going to ask her. So even though your child was a stillborn and you're in a hospital and there's a call button in the restroom, why did you decide to place your newborn in the trash bin rather than call for a healthcare person to come help you? Yep. She's not gonna go up there.
Yeah, that's what I estimated. But a lot of that.
Like, what would she say? Oh, I was trying to do them a favor and discard the body for them so they didn't have to do it. I don't know what the hell she's gonna say, but she ain't gonna go up there and testify.
Goes to jury selection, but if we do, and I don't know if Ms. Luce has found this to be the solution as well. I found if we do a decent supplemental jury questionnaire, that cuts down on the amount of time we need for voir dire. So we may be able to get it done within 4 weeks if we're not having to do.
So you're counting the 6 weeks, a good part of that you're counting also pulling a jury, right?
Hey, Jared.
I am.
Okay. So the actual trial portion won't be 6 weeks. You were accounting for finding a jury to sit.
Right. I counted 2 weeks for jury selection.
Okay. All right. Well, we will keep that in mind, and I will just try to start anticipating and plan ahead as much as possible on getting that taken care of. Okay.
Mm-hmm. Yeah, her lawyer in opening statement or closing will probably just be like, she was so shocked that she was pregnant. She was so shocked and the baby was also dead that she didn't know what to do and she panicked. Like, they'll probably just throw something like that. But even so, when you're on the panel of the jury, like, I don't know how you would even, I don't think you would give her any sympathy. I don't know. It's like, yeah, that sucks, but you're at a hospital. You're not like at a fucking McDonald's. And yeah, it's going to be a tough one.
All right. So that issue's off the table. I've got 2 other pending motions. I have the one to modify conditions of release. Then I have the other, which is the motion to suppress, motion for protective order, exercise of privilege, and the Pena Espinosa procedure determination. Which one do you want to handle next? You're muted, Mr. Mitchell.
Let's do the privilege one next. It's
okay.
All of them, because I think I can argue the whole thing, and we'll save the the
Hey,
release
Gothic.
provisions to last. There's
Okay.
also a motion that I filed. The state didn't respond, but to take the deposition of one of these, I'll think here just a second.
I'm also a little surprised that I mean, maybe it's blurry, but it looks like she's just wearing a t-shirt. Listen, I've been to court before, okay? When you go to court, you wear your best outfit, you wear your button up. Like, I don't know, even if it's a Zoom call, I think you should supposed to be dressed up. She might be, maybe I can't tell, but she looked like she wearing a t-shirt back there.
The toxicology experts, it's in Pennsylvania. The state's
I don't know, maybe it's a polo. Oh, yeah, maybe I just can't see. Maybe it's all pixelated.
some of their lab testing to Pennsylvania,
Hey, Marissa.
and I didn't want to be without that expert for whatever reason. But that's something we can do later. But we probably need to take the deposition for purposes of trial of that particular witness. So we're not either one of us hung out to dry when we need that toxicologist, and we don't have them available because they're more than 300 miles away.
So this is a toxicologist for the state, and you need the deposition of this toxicologist. Am I right on understanding that?
Right. At the preliminary hearing in this matter, the state objected to my just getting into that with the forensic pathologist and or any other doctors, saying we needed to have the toxicologist here. I want to avoid that. I've dealt with that issue with the same toxicology group before, where we tried to bring them from Pennsylvania and or the state tried to bring them from Pennsylvania. And normally somebody calls me and say, Gary, can we take their statement or their deposition? And that's all I'm saying. We just need to take the deposition.
Okay, but that's not right for today. We're going to have to put that up for another hearing, right?
That's right, Judge. I'll talk to Diana about it, to the district attorney about it, see if we can reach an accommodation, if we can take take that witness's deposition and introduce the report. The report's what I need and or the state may need, whichever one of us needs it. Thank you.
Okay. All right.
I'm ready to argue on this motion to exercise of privilege. Let me,
Did they? They made her look like she was like 13 years old.
Brooke Schuyler Richardson.
Was it when she was testifying? Did she testify? I know this one right here. Look, she looked like she was like super dressed up.
let me say, and there was some confusion yesterday, but we didn't send these exhibits, but to the court via your email and to the district attorney via her email. So these are exhibits I still think need to be sealed for purposes, but I sent exhibits A through I.
No, she's moving. It does look like a cardboard cutout. Here, I can zoom in. Oh shoot, did I just lose it? Where'd I go? Please zoom in. You can. She's moving. Here, I will. You can see her. She's moving.
Just for the purposes of this
Yeah,
hearing,
she
they're
blinked.
not to be admitted at trial or anything. I'm not asking that. Just for purposes of the hearing, they
That would be hilarious though if she wasn't able to show up and she was running late or something. And I'm just kidding. That's too much work. That's too much work. She's
included
moving.
the records of the hospital, which I think are privileged, and for the court's edification, the two lab reports that we needed. And then we had certain police reports, and I noticed and looking here, both officers are present. I guess we could take their testimony if we need to, but I attached their reports, Williams and Anaya. And then there's a videotape that the state doesn't have that I'm aware of, nor do I have, but I've seen on people send it on social media. It's from Artesia General Hospital, and it's a videotape of my client
Leaving the
going
bathroom?
from a examining room down the hall to the bathroom and then coming back. Another Artesia police officer took that tape, figured out a time schedule. That's Exhibit G, a timeline. I believe that was Officer Minter, and I attached his report showing the timeline. And then there's the videotape that we seek to suppress, where police officers, the doctor, and my client are and her mother are in the examining room. That's the Miranda issues. And then I did a timeline of events to give the court without you having to.
Wait, what Miranda issue though? I thought you're only read your Miranda rights if you were taken into custody. I don't think they were taken into custody yet. It was just like they just showed up. Hey, there's a dead baby here, and they're like doing their investigation. I think she was. I mean, obviously she wasn't free to go, but like, did they say that she wasn't free to go? I think I remember saying that. No, but she had nowhere to go anyway. Sorry, because she had to be transferred into the hospital because she was like bleeding and shit. But yeah, I don't think she was like arrested.
Examine every medical record to give you a timeline of what we're talking about here. So I'm asking that those be admitted for purposes of this hearing and that they be sealed.
All right.
Yeah, that's why I'm confused why he brought up the Miranda. You read your Miranda rights when they're like arresting you.
Objection, Ms. Luce.
Your Honor, I don't have objection to the video, to the police reports, to the lab reports for purposes of this hearing. The timeline that has a caption on it appears to be Mr. Mitchell's work product summary of what everything purports to be. And
Yeah, okay, so I'm just looking up really quick to make sure. Detain and arrest are connected but different. Detainment may not result in criminal charges, where an arrest will. You may be detained because an officer suspects that you know about a crime or that you are connected to a crime, and their suspicion is reasonable and valid. And then Miranda rights is when they're about to take you in and ask you questions. So I don't think they even asked her any questions. I think she was one that just like blurted out. The doctor was like, hey, we found a dead baby. And then the mom looks at Alexee and she says, nothing was crying. The baby was dead or something like that. Yeah, I'm confused about the Miranda rights part, but we'll see what the lawyer says.
purports to happen. If that's a proffer by him of what evidence is, and the court is to consider it only as a proffer, the state doesn't have an objection. Otherwise, that's basically argument. And the state's going to object to that being a written document with us only getting it last night coming in before the court.
Okay, I saw a thumbs up, from Mr. Mitchell, right?
Judge, and I knew that, and I expected to just use it as a proffer of what the records show. Ms. Luce didn't say anything about Exhibit A, which are the medical records that came from Artesia. I copied those straight from what the state gave to me. So I don't know if the state has an objection to those. You're going to have to look at them some point in time to decide what is going to be admissible and not admissible under the privilege.
Now, counsel, I don't have any of these actual exhibits you're referencing. Where are they? Have you tendered them?
We sent them to your TCA via email yesterday, and she should have them.
You did? Okay, she said she sent them to my email. Let me check. I'm sorry, I missed them on my email if she did. Hang on a minute, let me look.
Nothing was crying. Yeah, I think she did it so quickly that she even bothered to check or even care, maybe, to see what the gender was. That's
It's
what
a
I'm
lot.
thinking.
It took several emails. I think we put them on a.
Also, if the baby was already deceased, why would you wrap the baby in plastic and tie the top? Why not just place it in the trash bag? Unless it needed to be suffocated. I don't
I'm
know.
not sure. I've got one that does not appear. It's a reference.
Hey, Rhiannon, how are you
Here's the
doing
link for
today?
Exhibit F.
You think she freaked?
That's not it, right?
Well, there's an Exhibit F, but we put them on a link for purposes of the court. I didn't anticipate that you'd be able to go through them all. I figured you might take some stuff under advisement after you heard from counsel today.
I will do. And Emily, will you do this? Print them up for me. Just print them in. We'll put them in a folder also, because it just helps me to have them in hard form. She'll get them up and I'll look at them later. Will that work for you folks as far as this goes?
It will, Judge, because
Okay.
the argument is going to be, anyway.
Okay.
I do need to know if the state objects to Exhibit A, which were their medical records.
Your Honor, not for purposes of this hearing, for the court to consider them. Of any objection to any of these, as I've let defense counsel know, being sealed, not public for purposes of the record for various reasons. And so I don't have a problem with that, Your Honor, but I just wanted to make sure that the one that is, I believe, the timeline of events was the proffer to the court. since it had a caption on it, appeared to be prepared by Mr. Mitchell or along with his staff.
It was prepared by me, Judge, and a proffer is all it is. And
Okay.
that's really put the style of the case on it. So
Okay. Okay.
all right.
So, all
I'm ready.
right. With that said, let me hear your argument, Mr.
Sure, Judge, and I'll be as succinct as possible. And when the court reviews the argument that Ms. Luce made regarding HIPAA and the argument I made, we both agree under the law, there's not a remedy under HIPAA for one exercising the privilege. There are fines that a hospital and doctors pay for violation of HIPAA, but that has to do.
So remember, a couple days after she was arrested, the mom was saying that like she thought the hospital was breaking HIPAA because the news got out that the baby was found in the trash bin, and she was getting calls from like the teachers and stuff like that.
With the Department of Justice and their investigation and Medicare and Medicaid and whatever
Judge is
they
fine.
decide to do. But for the individual, there's no remedy under federal law under HIPAA that you could exercise. You can't sue for damages or anything like that. So my purpose in bringing this today, however, is under New Mexico law, and I cited the court to this. Rule 11-504 is a physician-patient privilege in the state of New Mexico that we believe applies. And I, in my brief, cited the court to Bertrand and Roper, which are the two key cases for the exercise of that privilege.
The no contact order between her and her, I guess I'm just calling it ex-boyfriend. I'm assuming they're not together. And I don't say it's like, okay, we'll be together, but we just can't contact. Yeah, I don't know. They're probably exes right now.
Our position is we have not waived this privilege in any way. We did not sign a waiver. It applies to the doctor. It applies to all hospital personnel. It applies to Artesia General Hospital. And later on, it applies to the hospital in Roswell where she was taken. So and that's one reason I attached a timeline so the court could know. This entire case hinges around what happens in a bathroom and the emergency room of Artesia General Hospital on the date in question, which was January 27th of 2023. The timeline will tell you that there's one admission sheet that says 12:03, but by 12:05, she's in the emergency room. And then within a few minutes, she receives medication and through an IV and including morphine and several other different kinds of medication. It's a timeline would reflect. Without getting into that too much,
Hi, Shirley.
she's examined by an emergency room doctor. She has a nurse that's there. People come in. The hospital asks for a UA, and blood. They do a blood test, and by 12:51, they know that she's pregnant. And then we know
What's UA, like urine analysis, I think?
when it comes to this privilege that according to and they happen to have a video camera or some type of camera in the emergency room part of Artesia General Hospital that shows her.
You mean the security camera? I don't know the way he's pitching it. Makes it sound like they're just like, they just have cameras waving around recording things. You mean the security footage?
Leaving her room, and we know from the records that at 1:39, she leaves her. They go in, they unhook her from the IV, let her get up. She virtually runs down the hall, trots down the hall to the bathroom, and then, according to the police report that you have from Officer Minter of the Artesia Police Department, who reviews that video and goes through it, she's in the bathroom for approximately 18 minutes and then leaves the bathroom and goes back to her room and then by a certain.
Yep, Danielle, if it went down how we all think it went down, the fact that she traumatized the hospital workers and then now saying it's their fault, like, oh, dude, that's crazy. If it went down the way that we think it went down, it's okay, Danielle.
Time period And let me pull that up so I can speak intelligently to the court.
It's okay, Gary Mitchell. I'm going to speed him up a little bit.
We know
1.25.
that.
Is that okay? He's at 1.25. Okay, he talks a little bit. It's not really smooth.
After the 18 minutes in the bathroom, we know she's back in the room, and we know that emergency room personnel go in and they begin. The cleaning staff goes in and they begin to clean the bathroom, and later at and that begins at 2:08, and then by 2:27 they find the baby, and at 2:38 the doctor pronounces death, and then police arrive after that. So when the police arrive, the doctor wants to wait for the police to get there.
Hey, Valerie Ivy, welcome. Thank you so much for joining the membership. Welcome, welcome. Enjoy your emotes and your badge.
I don't think this is disputed at all. She waits to talk to the two officers from Artesia Police Department, both of whom I've attached their reports, the sergeant and the officer that came in. And I've attached those as exhibits. So they come in, they talk to the doctor, and then they go in the room where she is. And the doctor walks up to her and asks her and tells her they found the baby and asks her, says something to her. You have the videotape of that. It's a lengthy videotape for you to examine that time period with the officers there. The officers both say in their report that they told her she was detained, could not leave, and for purposes of Miranda, I would argue in custody and not free to leave, which means that at no time is there anything read about Miranda, which gets us to the suppression issue. But back to the privilege, the key question is to determine, when does this privilege apply? Well, it applied from the first time she went to the hospital. That's real clear under the rule and under the case law, and it applies to everybody there. And really the state's case is the time in the bathroom. And then it applies afterwards as well. So
this lady was in shock. It's been happening since the beginning of time. Wait, what's been happening since the beginning of time? Like stillbirth? Said something to her, way to play it down.
My position to the court is everything that takes place between the time
Valerie.
she goes to the hospital all the way through is privileged information that the doctors and the nurses could not give out to Artesia Police Department, could not give out to anybody without a waiver from my client, and we've never waived it.
Wait, but what about the fact that the baby was found in the trash bin? How would they have... That needs to be reported, no? Sorry,
and then it applies afterwards as well. So my position to the court is everything that takes place between the time she goes to the hospital, all the way through is privileged information that the
all the way through to what?
Doctors and the nurses could not give out to Artesia Police Department, could not give out to anybody without a waiver from my client, and we've never waived it. In addition,
now, are you talking statements made by her and her medical records?
Yes, Your Honor, and that would also include lab reports and stuff. Okay. Anything that happens at Artesia General Hospital, and there's a case on that as well that says, hey, that includes lab.
Yeah, I want to look at the annotations. I don't see that. I'll have to pull. Let me ask you another question. Is information, because obviously cleaning staff, what, about 2 hours after the event? Is that what you said? They go in around 2 a.m?
Yes.
Around a little past midnight. Cleaning staff goes in around 2-ish, right?
That's correct.
And they discover the deceased child.
Yes, after they're in I can tell you the exact times on that based upon the records and stuff. At 2:08 in the morning, the ER staff, janitorial staff started cleaning the bathroom. At 2:27, they call in a male nurse because of what they found in the bathroom. They found the baby. Okay. And then that nurse takes the baby into an examining room. And at 2:38, the doctor pronounces the baby deceased.
So let me ask this. Notwithstanding a doctor-patient privilege, what about the hospital's obligation to report the deceased child? Is that
that's what we're saying.
That privilege? Are you claiming that as okay?
That's what we're wondering. Okay.
That's
he says no.
Okay,
he says no. Okay.
They have a duty to report it. They call 911.
Okay.
It turns out that the police were there. The emergency room wasn't busy, but it turns out they were real close by anyway. And they were there quickly. But now they have an obligation to report it. I'm not saying that. I'm saying this, and I'll try to be as succinct as possible. Really, the state's case hinges on what happens in the bathroom, and there are no other witnesses but my client to that. And whatever the experts are saying, whether it's OMI, my experts, and such, are going to say about that. But basically, that's the situation. Is if for that 18 minutes, there are no other witnesses. But everything before that, because there's no case before, she doesn't have the baby except in the bathroom, Judge. That's the point. And before that, there were no issues that I think aren't covered by the privilege. And then after that, obviously, she's they end up.
Yeah, I mean, at this point, I don't buy the shock part. Unless they're going to prove it in trial to show that she clearly didn't know she was pregnant and she was really in shock and stuff. But at this point, I don't buy the shock, but, you know, I'm open, but we'll see. Because, you know, based off what one of the nurses said, she said that Alexee Trevizo asked her, what happens when you stop taking birth controls and you stop taking weight gain pills? It's like, well, why would you stop taking birth control pills? Oh, it's because you probably think you're already pregnant, and birth control pills don't work when you're already pregnant. I don't understand why she just didn't. I don't know. Is abortion like expensive or something? Like, if she really didn't want that baby that badly, why not just secretly just have one without telling her mom? I don't know. I don't know what the New Mexico laws are for abortion. Let me just look it up. Maybe no money. Oh my God, I can't type today. New Mexico, abortion in New Mexico is legal at all stages of pregnancy. Because I also want to know, how did she get the weight loss pills? How did she get her hand on that? This is per Wikipedia. I don't know. Like, if she didn't want the baby that badly, like, why not look into other means and methods?
Taking her to a room.
Like, if she didn't want her mom to know,
people see all the blood, and they realize they have to do some examination. The doctor goes in, doesn't talk to her because they don't know that she had a baby, but they think there may be other complications. And then after they confront her, the doctor and the two police officers in her room, then after that, the doctor intervenes again and says, listen, I got to helicopter her. We got to.
Well, what I also want to know is, does she have like a job? Like, how did she get them? Like, where did she get the money from? Like, how did she get all this? You know, did she steal money? Like, what does she do? That's what I want to know. If she had a job, then okay, then yeah, she probably just bought them herself, you know. But like, I don't think it was ever mentioned that she had a job. I think she just does full-time student, and then she has like a bunch of like hours dedicated to like cheerleading shit.
Back her to Roswell. We don't have people here in this hospital to take care of it, and she is bleeding to death if we don't get her treatment at Lovelace and Roswell. So they airbacked her to Roswell after that. And of course, the police let that happen, although she was in custody at the time that they went into the room. The doctor specifically states in the reports, and this is not in dispute because it's in the records and it's in the police reports, the doctor deliberately waits after they find the baby, the doctor deliberately waits until, and no other staff goes in, until police officers arrive, and they all go in at one time. And that's where we get into the Miranda issues. So for the privilege, I'm saying everything's privileged up to the time she goes into the bathroom. Everything's privileged after she comes out, because it's all part of the privilege.
But it's until the baby was found in the trash bin.
Okay, now let me stop you there because I want to clarify. I'm looking at Rule 504. We have the doctor-patient privilege. This is an exception to the other rules. Who has the obligation? Does the doctor, and is this in case law? I'm not saying it here in the privilege. It says who may claim the privilege. Is the doctor obligated under this act or anything else to invoke it, or at least advise the patient of their privilege, or invoke it on behalf of their patient? What is their obligation?
The doctor and the hospital's obligation is, until they have a proper waiver of that privilege, they can't talk about it. And
He has to make a knowing waiver after being advised what her right is in event to waive it.
Well,
right.
There's no case law on what a knowing waiver is. That's always been, did she sign a waiver? Okay. You know, we've always done that on a case-by-case basis. I'm not going to tell you that I have a particular case, although having done this in civil cases and in other cases, classically, there's a written waiver that is signed that you can waive that. And that's not done in this case. And my client is not a child. She was 19 at the time. They had the waiver from her. They never got it. And here's the problem for all of us in this case. There's a huge problem.
Huge problem.
Is mass media, social media, how it got out is, I guess, an issue that the district attorney and I will have to look to sooner or later. But the truth is, it got out. All these records, all these videos were out. Now, somebody from Artesia had to disclose that. Every one of them gave a statement to police they shouldn't have without a waiver. They all gave records they shouldn't have without a waiver. They gave a video they shouldn't have without a waiver. Or and classically, when you read the case law, there are three ways. Number one.
Wait, did this blow up? Because I don't know if it blew up before Law and Crime posted the body cam footage. That's how I knew about it. There was like a footage that was uploaded, and I remember I was like, "Holy shit, what the fuck is this?" And I watched it. And it was fucking wild. I don't know if this blew up on like social media before. Do you guys remember?
You get a waiver from the patient.
And then also, did it blow up before or after she was arrested? I don't remember either. Was it afterwards? You think it was before?
Number two, a court orders it. There is no court orders in this case. They didn't go down and say, "Judge, we need a search warrant. We need an order from you, ordering the hospital to turn over the stuff to us." They never did that. They just did it. And then, in fact, there's a videotape in this case where the officer goes in and asks the administrator of the hospital, "What do I need to do?" He says, "Well, just send me an email." That doesn't cut it. It doesn't cut it under HIPAA. It doesn't cut it under this rule. So my point is that the privilege applies. Now, I could choose to waive part of that as her attorney, or she could waive part of it. We haven't chosen to waive any of this. And as a matter of fact, the state knows this. At the very beginning of the preliminary hearing in this case and the motion, what I did was
Oh, no, Gary? Gary, you're muted. What happened? Wait, get transcript.
Mr. Mitchell,
Oh.
I was muted. You're muted. Something happened. I don't know what. Can you?
Elaine! How did Elaine get here? Get Elaine's hands off the microphone.
Can you repeat everything you just said? I am sorry. It just, my screen muted you.
I don't know how long I was muted for, but here.
Let's go back about 60 seconds, I think.
Well,
I'm sorry.
here's the point, Judge. I've never waived this on behalf of my client. My client's never waived it. At the preliminary hearing in this matter and the motion to set conditions of release, I objected right before we ever got started receiving evidence to the court exercising the privilege, alerting the court to the issue, alerting the court to HIPAA, alerting the court to the doctor-patient privilege, and my belief that it covered Artesia General Hospital in this case. Mm-hmm. And he gave me a continuing objection throughout the entire hearing, and I've never waived it since then, and I've never waived it before this court. So that's what we think is covered by the privilege. So all these medical records, all of these statements by doctors and nurses that were taken without waiver.
There was a troll in the Zoom meeting? How do you know? Hold on, I'm gonna get some more water really quick. I just drank all my water. Guys, get some water real quick. Be back in 2 minutes. Okay, I'm back. Is that 2 minutes?
All of the lab reports, not the state lab reports, not those that come on the examination of the baby, but those that were examination of my client, that would be the blood test results, pregnancy test results, things of that particular nature. All of that is privileged. Everything there is privileged and should never have been disclosed. And we need a determination from the court that it's privileged. And if the court decides it's privileged, then unless I waive it, or there's another, and I don't know of any other reason, because the privilege is a privilege, under Roper and Burchard and the rule, that remains privilege and cannot be used in court. So that's the argument on the privilege. And I'll submit it to the court in that regard. And then we can argue the suppression issue later.
Okay. All right. Thank you. And I'm looking at the act. Privilege is that to be claimed by the patient or their guardian or custodian, which doesn't apply. It is a personal right by the patient. And it says who may assert the privilege on their behalf would be their physician or whoever treats them.
Okay.
Authority to claim the privilege is presumed, absent evidence to the contrary. Exceptions, well, it says by order of the court. Okay, so I understand what I'm looking at. Let me hear your side of this argument, Ms. Luce.
All right. State's turn.
Your Honor, basically defense in their motion raised three issues. They raised the issue of Miranda, they raised the issue of HIPAA, and they raised the issue of privilege by the rule. Let me start with the issue of Miranda. The issue of Miranda, she was not in custody.
Right.
Statements that she made when some police were there were actually statements initially that she blurted out. Officers asked her no questions. And
remember, I wanted the doctor to not stop her, but do you guys remember when the mom was like going at it with her daughter and the doctor was like, stop. Like, stop. I wish the doctor just let them continue because I wanted to hear more stuff. But, if anything, the doctor kind of helped and stepped in at that point.
Her mother, who is present with her in the treating room the entire time, is saying things to her, and the officers actually tell the mother to stop, that she, has Miranda rights and that she should be advised. And so we think the Miranda issue is really not an issue. There's not a violation of Miranda. And we put that in our response.
Oh, I actually don't remember that part though. I remember the officer telling the mom, like, if she's not gonna chill the fuck out, she needs to like get out of there.
The second thing is HIPAA. The defense puts HIPAA in here. HIPAA is really a right of hearing. Has nothing to do with the criminal case. There's no remedy. It's not a constitutional protection. It's a statutory protection in which a penalty can be against the facility, the physician, and that is the civil suit that two civil suits, I believe, that defense counsel has already.
Yeah, and I think Mr. Mitchell doesn't disagree with you on that point.
Right. Well, no, but he put it in his motion, Your Honor, and so
okay,
for purposes of the record, the state's just making an argument.
He acknowledged to me that the HIPAA is it's a federal issue. It's a remedy that doesn't even run to the patient, apparently.
Right.
Right.
So it really had no place in his motion, but it was there.
Okay.
So the third is the rule. And so let's start with defense has kind of combined a lot of things together. Statements made by treating personnel, doctors, nurses, records, video. He's kind of lumped all that together. The state doesn't believe that's proper. First of all, the defendant's mother, this defendant is an adult, the defendant's mother was present at all times. You can't have privilege if a third party is present in the room. And so.
Okay. Oh, no.
You just went mute again. I'm having trouble with this.
Is this Zoom?
I think it's our system. Okay, go ahead. It's about 10 seconds. Okay, go ahead. I think.
The defendant's mother is present in the room with her at the emergency room. She's not with her in the restroom, but she's with her when the nurses, doctors, anyone is speaking with her. You can't have a privilege.
Hey, Internet Pro, thank you so much for joining the membership. Welcome. Enjoy your emails. Join the Discord if you haven't already. We have a true crime section.
In the room with her at the emergency room. She's not with her in the restroom, but she's with her when the nurses, doctors, anyone is speaking with her. You can't have a privilege if you have a third party present. You've already, by your own actions, letting your own mother be there, waived that privilege. So statements that are made are not going to be protected under this rule. She's an adult. If she was a minor, that would be different. So statements, that's one thing.
You're muted again.
Records, the hospital records, the police department was given the records, but they did apply for a search warrant and obtain records properly by court order. And so a claim of privilege that we didn't get them by court order for a crime, the state believes that that is the exception and allows us to use those tests from the lab as well as the records. The third thing is apparently.
Wait, so they got a court order for that? Wait, what is Mitchell saying again? I'm going to have to go back to Mitchell. Mitchell, what are you arguing again?
The claim of the security video for the hospital for the hallway.
Security, yep.
The state would submit.
You're muted again. Okay, go ahead.
Yeah, Your Honor, it's showing that there's somebody on as a participant that is muting people, just so that the court knows.
Okay, that's good to know. If anybody's trying to mute, please stop messing with the system, all right? You can mute yourselves, but please don't mute my.
Wait, what kind of system is this? Why is there a system that allows people to mute other people? Wouldn't there be like admin privileges? Sorry, I've never used this thing before. This is Zoom, right? What the hell is this?
Litigants here. All right, go ahead.
So, Your Honor, the video in the hallway, defense is arguing that that video is privileged.
Okay.
The hallway would be a public corridor within the hospital. It's not a private patient room. It wasn't the restroom. The fact that other people can access that hallway and be in that hallway, we don't believe that there's any right of patient physician confidentiality for a public hallway. It wouldn't be any different than when the court has a closed proceeding in the courtroom. Whatever's going on in the hallway of the courthouse is not a protected, secluded area. And so for them to try to argue that because it shows a bathroom in the hallway where she comes in and out of, that doesn't make it patient protected privilege. So I think really you have to separate out the three.
Again, go ahead.
The three types of evidence involved, from statements that are made where her mother is in the room and then later the police are in the room. It's definitely argument for defense counsel to say that the doctors deliberately, intentionally waited for the police to go in. I think that's probably at this point an assumption on behalf of defense counsel because we've had no doctor testimony to say that. But either way, the fact that the mother was already in the room, there's no right of privilege.
So you're talking about the memorial. Yeah, I couldn't really see the picture of the memorial. People were pointing it out in the body cam footage. This right here, right? It says like Alex and like that looks like it was wings, but I couldn't see the rest of it. I'm not really quite sure. I can't see shit.
There's no claim of privilege that's been waived. She came with her mother. She allowed her mother to be present. The court would be familiar that a patient has a right to not have other people in the room. They ask if it's okay if that person stays. That's normal treatment. The state would submit. So, Your Honor, we believe there are three different things going on here. And for defense to lump it all in and say it's all privilege before the court, we would disagree. And so we don't believe there is a privilege based on our argument to the court. I do have the officers on if the court wants to hear from them, since it is a motion to suppress of what happened once they were there. Once they were in the room, they were then had body camera. The reports have been submitted. I don't know if the court deems that sufficient. If you want to hear from them, that the state is glad to put on these witnesses. We would also ask Your Honor to be able to submit proposed findings and conclusions because this is a rather intricate argument, and I believe the way the defense has framed it and the way the state is framing it are very different. Thank you.
All right. And it is apparent to me there may be some distinct acts or events that occurred that are privileged or maybe privileged. I'm seeing other. I can't lump this into one event, a long-running event. I think we've got, for example, I'm thinking that the whatever happened in the hallway, which I think is just a video of her going from, I guess, a treatment area down the hallway into the bathroom, right?
Mm-hmm.
That's a public area. I can't see that video would in itself be a privileged video. I've got other questions about it.
Oh, I see the trolls now. What? Shouldn't like the legal, I don't know. Maybe you can't make it so people can't just write like random shit in here. Someone wrote, ooh, woo, woo, hee, hee, Michael Jackson. Oh my God.
Parts. I do think it's a good idea that you submit findings of fact in this case. I'm going to go back to you, Mr. Mitchell. I've got to tell you, I don't know how much of it I did see, but I was aware, I think it was around the time the pretrial detention hearing was occurring, which I did not conduct. That was not assigned to me. That was Judge Finger. There was something on the news, one of the Albuquerque channels, which I think was the video you're referencing. I think there was a physician, I guess he was an ER physician.
Judge, you're on mute.
Yeah, I just was. Who is
Jad something? Jad.
Okay, somebody named Jad SD56 is muting us. Please stop. I'm going to have to ask him to leave this hearing.
He just left the meeting, Your Honor.
Okay. Well, that helps.
That's the person that was running the uwu thing.
And Judge, you were asking a question when you went on mute.
Yeah, I think I was telling you that I saw part of, I was just passing through a room in my house and there was some news report. This was immediately after the pretrial detention hearing was conducted. And it shows a video. It shows I think it's the ER doctor. I don't know. I believe it was. And there was a police officer. I thought it was a state policeman, a police officer. And there was conversation going on. That's about all I know about that.
Okay.
That's the one you're referencing. Is that right, Mr. Mitchell?
Oh, is it the one where when the officers first arrived and talked to the charge nurse?
That she was
No,
not-
And then the ER doctor came?
no.
No, that
Okay.
that came from an interview later on when the police are interviewing the various nursing staff. That's a charge nurse that you're talking about.
Oh.
That you were talking to. He also was the one that took the baby from the bathroom into an examining room and called the doctor
Mhm.
to come down. That's a charge nurse.
That's different. So talk to me about, here's what I have on my mind about the state alleges that Ms. Trevizo waived any privilege by allowing her mother in the room when she was in this, you say it was custodial investigation or interrogation. Does anybody dispute she was advised she was not free to go, right? Is that undisputed?
Well, they say so in their reports. And Judge, I gave you the video. You have the video among the exhibits I produced.
Oh, okay. Okay, I'll see that later then. So,
You can see exactly what happened. But really, in answer to the court's question, number one, my client's mother came with her into the emergency room.
Mhm.
And she was present, except when she went down into the bathroom. She was not present in the bathroom.
Mhm.
She was present during most of this. And then she was present later on when the doctor and the two police officers come into the room. Now, I want to be real clear about these facts. After the 18 minutes, you see my client go down the hallway to the bathroom. And then 18 minutes later, she leaves the bathroom and she comes down and goes back into the examining room. Now, the doctor went into the examining room to do a quick vaginal exam because they didn't know what had happened. They had not found the baby at that time.
Okay.
And they do a quick vaginal,
They didn't know what happened and she didn't tell them.
she gets undressed, they do a vaginal exam. None of that's recorded, obviously, on video. It's in the privacy of the room. The doctor's there, but they have not found the baby yet. And so, again, the mother is present then. I want to be upfront about this. And then the cleaning staff finds the baby, and then they call the charge nurse. The charge nurse takes the baby into an examining room, and then calls the doctor. And then it's after that. And this was testified to, and I know I say this very respectfully to Diana. She wasn't the attorney that handled the preliminary hearing.
This case is too much. Me and my fiance are arguing over opinions back and forth. LOL.
you're muted again.
I don't know what's going on there, but I'll keep my finger on it, Judge.
I know, I'm not touching a thing. And
We may have so many people on there that's the problem. Anyway, I was saying that after they find the baby, then is when the doctor, who also testified at the preliminary hearing, indicated she waited after they found the baby to go back and talk to her patient, my client, until police got there. They called 911. The police were there. We're not talking about a lengthy period of time here. We're talking about within minutes, really quick. And the police were there. The sergeant comes, the officer comes, and then then they talk to the doctor. They go in the room, and in the room at the time is my client, her mother, the doctor, and the two police officers
I feel like he just keeps repeating the timeline over and over again.
are standing, and she can't leave. And that's in
Okay.
their reports that by that time they've got this information. They have a baby that's deceased. They have a doctor. They have the baby, and they have information. And they're going in to talk to the mother.
And let me,
They could just make it so the Zoom meeting is not public. You know how like with the Koberger one? Koberger one's like they had like the Zoom link and the meeting thing, the number, but they like blocked it out so the public couldn't just join in.
interrupt you there now. Ms. Luce has asserted that because her mother apparently was already in the room,
Mm-hmm.
that statements made by your client were, I guess, impliedly waived because her mother was in the room and she's an adult. I think it's based on that. I mean, if she were a minor, it'd be a different situation altogether. Can you address that?
Yeah, can you just address it succinctly and just get to the point? He's just repeating the timeline.
Can, and you need to address it in two ways.
Okay.
Number one,
Let's go.
what
Point
is
number one.
the presence of the mother due to the medical doctor-patient privilege? That's number one. Number two, what does it do under Miranda suppression rules? Well, the latter first.
Oh, God,
Under
this might get
Miranda,
worse.
it doesn't matter who's present. They have to read her when she's in custody and she couldn't leave. The officers were there. They say it in their reports. And then
But they didn't
they don't read
question
her
her.
Miranda. The doctor asks a question. And you can't do that. I've cited some cases and wrote on that in the response or the reply to the response. And that's a different situation. And Miranda would still,
You're muted again.
and whether or not that gets suppressed or not is the determination the court has to make. That's a different and separate issue. Now, does the privilege at the hospital apply with the doctors and everything, with the mother being present? My position is, I'll try to do some further research on this. I agree with Diana. We need to do findings and conclusions and give you some case law about this, so you're not deciding this thing in a vacuum. But my position is the doctor-patient privilege still applies, because we do this all the time in hospitals. We have spouses present. We have family members present because they brought them in. And a lot of times the people aren't in their right mind to make decisions anyway and need a family advisor. We do this in hospitals all the time. I'm sorry, it doesn't get, wow,
Well, okay, you're good.
wow. It doesn't get rid of the privilege.
Speak faster.
It's my position.
All right. That's what I really, and that's going to be a real important factor for me to examine and I do think before I make any really hard decisions, you're getting my impressions on stuff, but I would really like to have your finding of facts, conclusions of law before I can really have to study this. So that's something I'd like both sides to give me some authority on about that.
Yeah, I'm surprised that Gary Mitchell didn't already have that. I feel like you would come like 100% prepared. You've been her attorney for like, I don't know, a couple months now, right?
Is it impliedly waived if you allow another person in the room? All right.
All right, Judge, that's that. I think the other issue was this that you had before you today was a modification of the release provisions. Judge Finger cited to the domestic violence section and issued a ruling that my client not have physical contact with her boyfriend.
So now we're getting into the no contact order. I don't know why they said it's a domestic violence thing, though. That's kind of interesting.
The father of the child. And even though I don't know what he could testify to in this case, that the state considers him a witness, they can consider him a witness. But here's the problem. And we've honored that. I mean, he was present during legal proceedings, but in the courtroom when we had for example, when we had the preliminary hearing, he was seated in the audience.
Okay.
Here's the problem that I'm asking. They both attend the same university.
Okay.
It's the second largest university in the state, but they both attend the.
You're mute.
Yeah, my client is trying to stay at home, and take classes from the.
No, here's the thing. I don't think the mom knew she was on birth controls. I don't think the mom knew. Because if the mom didn't know that she was having sex, if the mom thought she was a virgin, why would she take birth controls?
University. So we tried to avoid that problem this semester because I didn't have an order and hadn't had
Oh, because she may have killed her baby. That's why it's DV. Oh, gotcha.
this heard before then. But I'm asking that the court take a look at the motion and the state's response, because one, I don't believe we can order that in that fashion because of the cases I cited to the court, including Johnson and some other cases. And two, she has not violated that whatsoever. The judge allowed them to communicate via telephone and or, gosh, there's so many different media ways to communicate, but they couldn't be in person. And she's honored that. She doesn't go out at all other than to come to my office. The court allowed her to go see her grandparents. And other than that, she's at home. She doesn't go out. You don't see her at Walmart, anywhere else. But going to college and of course, her professors, even though she's doing this by Zoom, I'm not sure what they're going to require when it comes time for examinations as to whether she can do those via that method or she has to go to down to the university and take examinations. We're trying to avoid all those problems this semester. But in any event, we have some time to consider this, Judge, but wow. In case you need to have more time to look at it, or the state needs more time. But I would ask that restriction of being able to have contact and with her boyfriend be removed.
No, I think the no contact order was after they went to prom. I don't think it was implemented before they went to prom. Because I think it was implemented after her arrest, and she was arrested, I think, after the prom.
And that,
Maybe I need to write like a clean timeline of all this.
and the other reason for bringing this is I didn't want her getting in trouble in another city because they run across each other in a classroom or on the campus, even if it were by accident. I mean, we're just trying to do everything up front. There's not been any issue otherwise. Thank you, Judge.
Okay, let me ask you some questions because I'm kind of limited on what I can pull up and do my own research while I have my screens up here. I can't quite do that. It says I guess the authority that the prohibition was issued is under 3311B. Can you summarize that for me? What is that?
That is the domestic violence statute. Let me hang on just a second, Judge. I can pull it up real quick. Let me take the argument. Give me just a split second here.
Your Honor, it's the nature of the relationship.
Okay.
That's what the court was citing to in the conditions of release at the pretrial detention, defining continuing personal relationship.
That is correct. And
State's like, I got this. Don't worry, Gary Mitchell. I got this.
but my point is, this is not a domestic violence situation between the two of them whatsoever. And that statute shouldn't apply. What should apply is that we can't, I mean, she hasn't been convicted of anything. She's not on probation. And as long as they don't discuss the case, they should be able to see one another. And that kind of prohibition, and I don't want to get into all the marriage equality cases, but those are the cases in which really the rights that you have in that regard have been explicitly spelled out by our Supreme Court in the cases that I've cited to the court. All right.
Okay. Well, I was wondering because I was thinking that was under some domestic relations ruling. That's what I.
Oh, it's true. It is possible that she could have been taking birth controls for other reasons. Yeah, some people take birth controls because of like acne or like if they have like really bad periods. That's true, Gothic. Thanks for bringing that up.
Okay. So it's under the DV
Ooh.
statutes.
Yeah.
That's the party that was used to prohibit the contact. It's not because he's a potential witness. Is that right, Ms. Luce? He's not going to be a witness in the case.
Your Honor, he could be a witness, but at the point that Judge Finger made in the findings, he mirrored what Judge Shoebridge did in the Alexee Trevizo case, was that he did not want her to have a relationship that could result in a pregnancy. And we end up in a similar situation again as to what had occurred. That is what Judge Finger was doing in restricting. It was restricting contact. And the state disagrees with defense counsel that the court doesn't have the authority to do that.
Wait, did they talk about Alexee Trevizo, the other one that threw her baby in the trash bin?
The analogy would be a DWI case
also.
and the court saying you cannot consume alcoholic beverages while this case is pending. Once probable cause is found and probable cause has been found, this court can set restrictions to ensure that there is no conduct that could lead to a further crime involved in this case. And that is why Judge Finger made that restriction. He used that definition because, they weren't married. Maybe they weren't officially boyfriend, girlfriend. He used that continuing personal relationship to say that she was not to have that. The court can look at what happened in the Alexee Trevizo case out of Lovington with Judge Shoebridge. He specifically restricted her from having any contact with any male individuals that were not family individuals. Obviously she had people that lived in.
Oh, you can do that? I had no idea. I mean, with the alcohol and, with someone who got like a DUI thing, I could understand that. But like, wow, yeah, I actually didn't expect that. So they don't want her to get pregnant with nobody, just in case, this might happen again or in the future or something.
Her home with her. Because of the nature of what had happened, recognize in that case that child survived. This case is different.
Okay, so they are setting that case. Okay. She, by the way, got I think 18 years or something, or 20 years. Oh, fuck, I forgot.
And so the state believes that the court can fashion conditions of release that allows her to attend a university that the same individual could attend. Maybe they're in the same class, maybe they're in the same lab, the same bookstore, the same restaurant, but it's no different. There's no reason for her to have a relationship with this person based on what the facts of this case are at this time. They haven't made any showing that there's any, they didn't bring him in to testify. They didn't bring in a proffer of what's going on. And Your Honor, we believe that condition is appropriate based on these circumstances. You have to remember, Part of the state's case that we believe that is not privileged are her statements she made without being questioned by a doctor, without being questioned by law enforcement. She volunteered statements that she would not have to be given Miranda before she's volunteering a statement. She alleges she's not pregnant. She's not had sex. I mean, all those things. So we believe it's an appropriate condition of release. We believe the court can say that she can be in the same classroom with him. She can attend the same campus. That's not what the restriction is.
But it only runs us to this one person in this case, right?
That's right, Judge. It only runs to one person. And I don't want to get into other medical privileges that she has. Suffice it to say, I have made certain that she's had proper medical care since. And with doctors that I have lots of confidence in a different community.
Throwing the shade at Artesia General Hospital.
And
Proper care.
the Judge Finger was confronting
Confidence.
his fear. We've taken great steps to make certain that doesn't happen.
Hey, Deanna.
Well, I would really like to look at this more, but I'm going to go ahead and I'm going to modify the conditions of release. I'll allow her to go. It's New Mexico State and Las Cruces, right?
That's correct, Your Honor. It is.
Big university, huge. I don't know what the student count is, but I'm sure it's several thousand. Las Cruces is a sizable city. Personally, counsel, I'm really trying to get in my mind how you can invoke a domestic violence prohibition against personal contact. First off, nobody's invoked the DV statute. There's been no allegation of domestic violence. I don't think that translates into this. I really don't. My gut reaction is that does not translate. Granted,
Okay.
you can order that anybody who's under charges cannot commit any further criminal acts.
Mm-hmm.
And I certainly think that's absolutely reasonable. She should get her conditions revoked if she's gets charged with any further criminal acts, but I don't see how the DV statutes can even be applied in this case, notwithstanding what Judge Schubert said originally or anything else. Certainly, if she commits any other criminal act, she should have her conditions of release reviewed, absolutely. But I really don't think that a DV statute defining continuing personal relationship and prohibiting such can be translated into this situation. That's my read on it. Honestly, I think you can stretch that. I do advise that she may not commit any other criminal acts of any sort. I don't want her to get a traffic ticket or anything else. I will let her go to Mexico State. That's a big, big university.
Thank you, Judge. I'll do an order on it. Judge, how many days or weeks may Ms. Lutz and I have to do
I'm actually surprised that she's not going to do like online classes.
findings and conclusions? And I assume the state would rather I proceed with mine first so they can respond, but I don't care how we want to do it.
How do you want to do this? I wish I had a good clerk to help me with my legal research. You know, this is all on me, so you got little old me doing this too. So,
Well, Judge, what if I have my, Ms. Lewis, what suggestions do you have for when we
how
get?
long do you need to get a findings of fact to me?
Okay, well, Your Honor, we usually do 2 weeks. And then we'll give the, it's going to go first to the second.
Got somebody. All right, I'm going to mute them. But
If you're going to
Someone
have,
has been trying to get in and out constantly by using our names on here.
folks, I need everyone to mute other than counsel. Thank you.
Your Honor, 2 weeks is fine. I can get mine to the court in 2 weeks.
Okay.
Findings and conclusions on these issues.
All right.
And I'll do the orders on the other.
Okay.
And
and then Your Honor, if we can have an additional
Yeah, that's why initially I was confused about the DV thing.
week before we have to file our findings and conclusions.
Sure, that's fine.
that's fine with me, Judge. And do we want to do anything on that deposition situation today, Ms. Lewis, or would you rather we wait on that and you and I just talk?
Your Honor, I would ask that if we can't come to an agreement on it, that we set that at a later date.
Sure, that's fine. Okay. I got to tell you, both counsel, and I really do appreciate you're both rational, competent, really good attorneys, and I really enjoy having you in my court, and you save this court a whole lot of headache. I appreciate that. That's duly noted.
All right. That's all I had for today.
Okay. Somebody. Isabel is having a little hissy fit here on our sound system, I guess. I don't know who Isabel is.
Poor
All right.
judge.
Okay, counsel, and Miss Luce's screen. Okay, no, she hadn't. It was frozen for a second.
I think it's just a bunch of kids that's just on there right now, just fucking shit up.
All right. If you'll all prepare me the appropriate orders, what I'm taking under advisement is the issues on the suppression motion and privilege motion. And you'll submit findings of fact to me in 2 weeks and then an additional week after that. All right.
Yes, Your Honor. Thank you.
Okay. Thank you, folks. I appreciate you.
Thank you.
Okay. Thank you. We'll be in recess.
All right, that's it for the day. That's it for the day. One time your professor told us infanticide should be normalized. What was the context? Oh yeah, that's terrible. LOL. All right, y'all. That was the motion hearing for Alexee Trevizo. Let me see if they already scheduled like an upcoming one. They said 2 weeks, right, for the fact finding stuff. Trevizo, New Mexico. New Mexico. Hearing got bombed. Yeah. Trevizo. All right, so throughout that 1 hour, we saw her move once. She moved her arm to adjust her glasses. And she blinked maybe like, 20 times. Is it this one here? Dr. Jane, or sorry, not Dr. Judge Jane. Okay, so we got 8/23. All right, so next hearing date is, what is this for? Huh? $8/22 is the one that they had. 8/26 is jury trial. What? Who wrote this in here? Who did this? Is this the one they were talking about with the jury questionnaire? This right here. All right, so just to recap. All right, so initially I think Gary Mitchell, the defense attorney, wanted a change in venue, but that seems to be a kind of like a costly thing. So they're just going to send out a lot of questionnaires, lots and lots of questionnaires within the Eddy County, which is what Artesia is in. And they're going to try to find a pool of jury that's not tainted and doesn't know anything about this trial case. And that's number one. So maybe that's what this 8/26 hearing is about. I don't know. Maybe they're going to talk about the jury questionnaire or something like that. And then afterwards, what do we transition to? Defense was talking about how HIPAA was broken, how she had privilege. Anything that happened before the baby's body was discovered, she had privilege, I think. It was until the cops got there. Talked about how Miranda rights wasn't being read. But the state was like, well, she wasn't really being arrested. She was being detained, yes. And then they got into what was the other thing? Oh, what was it called? No contact order. Yeah, it was a no contact order between her and Devin, the father of the baby, the deceased baby. So they're going to go to the same university. But, judge says that she's going to let Alexee Trevizo go to school, attend her classes. The university's huge, they'll probably be fine. And yeah, that was basically just like a little summary of it. I guess I should have wrote it down. I was getting distracted. Sarah Boone lawyer filed a motion to withdraw. What? Again? No. All right. Well, that is it for the Alexee Trevizo stuff. Let me see Sarah Boone really quick. He tried to do that in December. Bruh. He tried doing it in December. The judge denied it. And Jesus. Frank Bankowitz, he wants out, does he? Sarah Boone, Orange County clerk. Let me look up Sarah Boone really quick. Sarah Boone. I'm not a robot. Or am I? Yeah, Ms. Boone is supposed to have her trial same date as the Koberger one, October 2nd. See what we got going on with Sarah Boone. Hi, Messy Ball. How are you doing today? Motion and withdrawal. Oof. Notice of hearing. Motion and withdrawal. Please take note the court has scheduled the status hearing for Friday, September 15 at 9 a.m. Is that on my calendar? Yeah, that is, right? Wait, September 15. September 15. That is not on my calendar. What is this September 15 thing for? Status hearing. Are they scheduling another one? Let me see. September 15, September 8, 15, and 20. Frank Bankowitz. So Frank Bankowitz is Sarah Boone's sixth attorney. She's had about, I'm trying to think how many attorneys withdrew because there was a conflict of no, not conflict of interest. How many attorneys withdrew because there was irreconcilable differences? I'm thinking 3. Was it 3? There was an attorney that was on her case for like the first 2 years. He withdrew because of irreconcilable differences. And then there was a couple that there was like a conflict of interest. I could have sworn there's another one that had irreconcilable differences too. Comes now Frank J. Bankowitz, Esquire, counsel for the defendant in the above styled cause, and hereby request that this court enter an order permitting court-appointed counsel to withdraw from this case and further representation of the defendant. In support of such motion, the undersigned states to the court as follows. 1. On or about July 11, 2022, the undersigned was court appointed to represent the defendant in the above styled cause. So that was about a little bit over a year ago. Number 2, due to irreconcilable differences which would have arisen between the undersigned and his client, the undersigned will be unable to effectively and properly continue representing the defendant herein. Number 3, defendant will not be satisfied with any attorney unless said attorney does not have a caseload and can dedicate his or her time solely to Ms. Boone's case. And Sarah Boone, you better hire your own attorney. Hire a private attorney. Hire an attorney. I don't know what public defender is going to be able to dedicate their time solely to her case only. Public defenders probably have a lot on their load. They probably got so many other cases and they just got to juggle their time. So she's just going to have to hire someone. You don't have any money? I don't know. Sucks for you. Public defender it is. Number 4, the undersigned has been in murder trials over the past 60 days. Okay, so he's super busy. I remember that. And is presently defending a capital murder case in Lake County, Florida, which absorbs all of his time, including weekends. Number 5, the best possible avenue is to have the defendant represent herself as... No way! Oh my God. Number 5, the best possible avenue is to have the defendant represent herself as no attorney can satisfy her. That was a jab at the narcissist. You know what? Let her represent herself. She can dedicate all the time that she wants to her case. Oh, damn. He really threw that in there. Wherefore, undersigned counsel respectfully respects this honorable court, enter an order granting this motion of withdrawal as counsel for the above defendant. I mean, damn. He said, represent yourself, Sarah Boone. Okay, well, let's see if is this Judge Wooden? This is Judge Wooden, right? Yeah, let's see if Judge Wayne Wooden, let's see if approves this. We'll see. All right. I didn't see that coming. DB gets released from prison to defend her. Oh, no. I don't know what happens when 2 narcissists just like bump heads together. I don't know. It would just be a bloodbath. I don't know. Yeah, even the devil's advocate wouldn't touch the case with a 10-foot pole. I mean, it's gonna be assigned to another public defender, but I just don't know what public defender is gonna be able to dedicate all their time to her, or maybe Frank Bankowitz did drop the ball and didn't give her any time, and she was trying to meet up, and she was trying to, because the last time we got a letter from her, she sent a letter to the judge saying that, like, hey, I have an investigator here, like, needs to contact my lawyer. Investigator tried to contact the lawyer, and the lawyer wouldn't pick up, lawyer wouldn't answer, I don't know, stuff like that. So yeesh. All right, well, if she represents herself, it would just be a shit show. Like, come on. Come on. No. I was distracted. What happened? 6 lawyer withdrawals, cites irreconcilable differences, says that he's really busy, has a capital case, busy on the weekends, weekdays, says that Sarah Boone wants a lawyer that will only solely dedicate their time to her and her only, and says that the only lawyer that should be satisfied with is a lawyer that will be her, that she should represent herself. Oh, gosh. Okay, well, that's Sarah Boone. All right, y'all. Well, anyways, thanks for hanging out. Today's a short stream, and I'm going to end it right here. So today, if you guys missed it, we watched the Alexee Trevizo in the motion hearing. There's supposed to be one happening in 3 days as well. So I'll kind of, I don't know, figure out what that is. This is jury trial, but maybe They just meant that they're going to get together for a jury questionnaire stuff or something. I don't know. I'm not really quite sure. But yeah, I'll look into that. And then for the sidebar stuff, we'll continue reading it sometime this week, maybe tomorrow. If I have time to look at the transcripts tonight, maybe we'll do it tomorrow. But other than that, thanks for hanging out. Thanks for joining the membership. Thank you for chatting. Thank you for your support. And thanks for having me in the background as well. Feel free, if you guys want, join the Discord if you like. Discord has a true crime section. If you have any cases, anything like that, you can post it in there if you want to discuss. Or if you want to, post cute pictures of your pets, you can post it in there as well. And then here's the social media stuff. I don't care about, Twitter. We don't care about Twitter, but I have Instagram and all that stuff. So feel free to check it out. Oh, I just uploaded my film camera photos on my Instagram, actually. Yeah, go check it out because the film stuff is really cool. Dude, we took all these pictures for film, and then a lot of the pictures were just really blurry because I didn't understand. I didn't know how to do the autofocus thing. So a lot of blurry pictures on there, but I don't know. Film is actually really fucking cool. But other than that, I might be in the Twitch later. I stream on Twitch as well, but we play video games on there. We don't do true crime on there. Not really. Well, I don't know. I was actually going to watch some true crime stuff on my Twitch sometime in the future. So if I do, I'll post it in the Discord. So you guys want to watch true crime stuff. But other than that, thanks for hanging out. I hope you guys have a great day. Take care. Go outside, get some fresh air, and have a good one. I'll see you guys a different day.